Hi, everyone, and welcome to tonight's webinar. I am Erin. I'm really excited to be hosting tonight's webinar for the McMaster community and really looking forward to getting started tonight. Just give me 1 second to make sure that my screen is sharing the right way, and then we will get going. So I have a couple polls that I'd love to start with tonight. So I'm going to ask my friends on the McMaster side to press go on those. And I'd also love for you to tell us where you're joining from in the world. And as it mentioned in the intro, you can put any questions at any time into the Q&A, but you can also put some questions into the chat or just kind of share resources or tips. I did get a bunch of questions prior to the session. I'm probably not going to have a chance to answer all of them, but I'll try to address as many as I can. And I did want to kick things off just by saying I am an estate planning entrepreneur. I am not an estate planning lawyer, and I'll tell you a bit more about that. And tonight's webinar really is about learning the basics of estate planning. It's about understanding the key components of a will, why you need one, and talking a little bit about the importance, but it's absolutely not meant to make you use Willful. It is absolutely meant to hopefully lead you down a path to visiting a lawyer, potentially using our platform if it's the right fit for you, but really just checking this off your list. So we work with lawyers all the time to refer complex cases. And if there are any lawyers who are watching who are estate lawyers, please put your contact details into the chat, because I know we had a question about a local lawyer that someone was looking to visit. So with that, I'll get right into the presentation. So first of all, I want to thank you for attending this very exciting session, because I know when you hear estate planning, you think to yourself, exactly what Jonah Hill is thinking here. Wow, this is a thrilling topic. I am very passionate about estate planning, so I hope that I make you laugh. I hope I don't make you cry, but I hope you leave here tonight with a few things that you didn't know before. I thought I'd start by giving you a little bit of my story and why I'm so passionate about estate planning. So really, Willful was born from a personal experience, which is so common for business owners. We had my husband, who's pictured here, who's also my co-founder, had an uncle who passed away a few years ago. And at the time he passed, he did have a will, but he just had never communicated any of the other wishes that he had around his funeral, his burial, where to find important paperwork. And so our family was left with so many unanswered questions, and it really brought up two main issues. The first being, why do we avoid thinking about death like the plague? Maybe not a good phrase to use in 2020. And then secondarily, and why don't we have easy ways to actually record these wishes so that we can share them with friends and family so they have them accessible when we pass away? So really, we launched Willful with a accessible to multiple generations of digital savvy Canadians. So again, the problem that we really identified is that Canadians just aren't thinking about or talking about their legacy. Our research shows that about 57% of Canadian adults don't have a will, and about 2/3 of people with minor children don't have a will. And of those who do, about 10% of them are out of date because you've gone through a life change, like moving provinces, getting married, getting divorced, etc. And I'll speak more about will updates in a moment. I can't see the actual poll on my screen here, so I'm going to have to pop out when I'm done sharing and see it, but I'm imagining that a good proportion of folks who are attending probably don't have a will, because that's probably why you are attending today. And I'm wondering if it's higher or lower than the 57%. And really, when we hear about the reasons that people don't have a will, it probably identifies with the reasons that you might not, or the reason that you might have put it off. The cost can be prohibitive. And again, we're going to speak about how lawyers are absolutely a great reason or a great resource for your will, especially if you have any complexity or you just want legal advice. But they can be expensive, especially if you have a very simple situation. And they're also expensive to make updates over time. There's also just the convenience factor. None of us necessarily want to leave our homes and interact with folks during COVID. And even the process of signing a will and getting witnesses in person can not be conducive to social distancing. And then finally, just the complexity. It can be really overwhelming. I talk to people all the time that say, I don't know what I don't know. Estate planning is not something I learned in school. It's not something I talked about with family. So I don't even know what goes into it. And I don't know the questions that I should be asking. And then finally, you add on top of that a little bit of good old fashioned human nature, in that everyone procrastinates on things that don't have a deadline. And unfortunately, we don't know the deadline of when we're going to pass away. And just the discomfort level of having to think about our own mortality. But there's this why now. Why is Willful kind of partnering with McMaster to offer unique discounts for you? Well, it's because COVID really brought to the forefront this idea that emergency planning is something that we all put off, but that really should be checked off the list. When COVID hit, so many of us didn't have wills, power of attorney documents, life insurance, emergency funds, all these things that the professionals tell us to get that kind of go down the to-do list because there isn't that sense of urgency. So when COVID hit in the spring, we saw a ton of folks, especially healthcare workers, who were looking to get their estate plans in order. And it's really become a hot topic amongst folks who are just prioritizing something they may have put off. So our mission at Willful, and I'm only going to talk about Willful for another 3 minutes, and then we're going to dive into the estate planning stuff. But really our mission, again, is to help Canadians prepare for and deal with death in a digital age using a suite of online tools. So we've started with call it the TurboTax for estate planning. Our platform, we work with estate lawyers in each province to make sure all of the content is provincially relevant and up to date. You, as the user, go through and answer a series of questions. You appoint key roles in your will, which I'll speak about. You allocate your estate. And then we give you a customized PDF with instructions that you can then print and sign in order to make legally valid. And unfortunately, you cannot sign or store your will online anywhere in Canada, so there is still paper involved. Again, we are very much designed like TurboTax, where if you have a very simple tax situation, you'll probably use something like TurboTax, and then you might graduate to an accountant later on. Willful is very similar. I'll get to the things that we can't handle in our platform and that may lead you to want to visit a lawyer. But really, we're designed for the folks with simple situations or who are just getting started on their estate planning journey. In terms of pricing, it's $99 for a will, $149 for a will, and both power of attorney documents. I'm not going to touch on power of attorney tonight just because we had so many amazing questions that I want to be able to get to them. But if anyone does have questions about that, please let me know. Or you can get discounts for buying plans for your spouse or family members. And after this session, the team at McMaster is going to send out an email with the recording of this session in case you wanted to look back at it, as well as a couple of resources to help you get started with your will, regardless of which route you choose to get it done, as well as a link for you to have some savings on your Willful plan if this is the route that you decide to go, or maybe you have friends and family that do have simpler situations and it might be a fit for them. And I know trust factor is big, so we are really big on highlighting our reviews and media coverage. So Google me or Google Willful, and you can learn a bit more about our story. And of course, it's all online, so you can do it, other than the printing of the will, you can do it all from your smartphone. So there's my shameless small business sales pitch for the Affinity program. We're really excited to be partnered with McMaster. And when we did build this partnership, Anne-Marie really said, we get questions all the time on this stuff. We offer, insurance discounts and other types of resources. It would be great to have you come on and just talk a little bit about wills in Canada because there is such a lack of knowledge on them. Excuse me. So that's what we're going to do tonight. I'm going to talk to you a little bit about what wills are, what makes them legal in Canada, the different aspects of a will, the different ways you can make them, when to update them, and then I'll get into a bit about what happens after you pass away. And I'll also try to work in as many of the questions as I received in advance. And as I see questions coming in, both through the Q&A and the chat, I'll save them until that section if I know that I'm going to address them, and otherwise I'll either speak to them in the moment or I'll answer them at the end. And a reminder that everything I'm talking about tonight is really legal information. It's not legal advice. And if you do want legal advice, you should definitely reach out to a lawyer. So with that, I'll start with just the basics. And for anyone who already knows this stuff, pat yourself on the back. I promise I hope to teach you one or two new things tonight. But really, when we talk about estate planning, what is your estate? Well, simply an estate is everything that you own. When you pass away, it's your estate that is going to be administered. And some of those assets will be governed by your will, and some of them won't be because they are what are called will alternatives. And I'll speak a little bit about that a little later. So this is a question that I always get. Why is this important? Why should I care about it? I often meet people who say things like, oh, I'm going to live forever. I don't need a will, or who cares? I'll be gone and it'll be my family that's going to deal with cleaning this stuff up. Or, I'm apathetic. I don't really understand why these things are important. So I really want to highlight that, like Kevin's family, who were sitting around after his uncle passed away, a will really gives a blueprint your family can follow so that you're removing guesswork and arguing after the fact. So it's really common for folks who don't have a will for their family to sit around and say, are we honoring their legacy? Are we actually doing right by them? And so a will gives you a voice after you've passed away, in addition to the other things that you can compile outside the will, which I'll also get to a bit later. It also reduces the length of time to wrap up your estate. So if anyone heard about Prince passing away, the singer, a few years ago, he passed away years ago, and his estate is still moving through the court system, obviously because it's so large and so complex. But even a very simple estate can take 12 to 18 months at minimum to wrap up. And that's before you add in the complexity of not having a will. So if you don't have a will, the court has to appoint people like guardians for minor children, and you have to, whoever wants to act as your executor, in this case, they're called an administrator without a will, they have to apply to the courts to receive permission to be able to act on your behalf. And they can't do anything until they receive that court permission, and that can take weeks. Not to mention, there's a minimum period of 1 year if you don't have a will where your administrator can't actually pay anything out to beneficiaries. So it puts money in your beneficiaries' pockets faster if you have a will. It speeds up the rate at which your executor can start acting. And it also saves the court from appointing key roles like a guardian, not to mention the reducing of the burden on your family, which tends to be the biggest reason why folks do care about estate planning. So what is a will? Well, often we hear all of these, all of this feedback about how wills are overwhelming because you have to gather your financial statements and you have to know your net worth. And oh my goodness, there's so many aspects to it. And I always try to tell people, at its core, a will is actually a pretty simple legal document that dictates who will take care of dependents and where your assets will go after you pass away. It doesn't have a detailed listing of your assets in most cases because those change over time, and because your will can become public domain when it goes through the court system, and may not want every relative knowing exactly what you owned when you passed away. And often it's the things that you create outside the will, lists of assets, contact sheets, life insurance policy, all of those things that you store with it that can take a long time to gather. But the will itself, as I hope I'll show you when I talk about the different elements of it, is actually not as cumbersome as you might be thinking. Another big question that we get is just what makes a will legal? I've heard that I can write one on a piece of paper. I've heard that I can sign one online. I've heard that I have to go to a lawyer to do my will. So this is what by law makes a will legal. And this is true across all provinces. So there are absolutely nuances across provinces, knowing that each province has its own legislation for wills and powers of attorney. But this is true across all provinces. It has to be created by you. So you can't create a will for someone else. You can direct someone to sign your will for you, but you cannot create a will for someone else. And it has to be done in sound mind. So you have to have the capacity to understand the nature and the effects of the document. And you also have to be over the age of majority, which is 18 in Ontario. There are exceptions to that, like if you're in the army or if you got married younger than 18, but in most cases, you have to be over the age of majority. Your will also has to be signed with a wet signature on paper. So even though there's some virtual witnessing rules during COVID, which allow you to get on Zoom and do the witnessing over Zoom, all of the signatures still have to be physical signatures on pieces of paper. So don't DocuSign your will. It won't be legal. And then you have to sign it in the presence of two people who don't benefit from your will, who also sign the document. So in that case, if it were me, I make the will, no one influences me or does it for me. I have the mental capacity to do it. I print out my will, I sign it in the presence of my two cousins because they aren't beneficiaries in my will, or their spouses, and they sign it as well. The law says it only has to be signed on the last page, but often people will initial each page just as a best practice. And that's it. So there's nothing in the legislation that says that you have to visit a lawyer. You can make your will multiple ways, although again, you absolutely may want to. In terms of who can be a valid witness, it can be any mentally sound adult. So again, they have to be over the age of majority. They have to have the mental capacity to be a witness. And they just can't be a beneficiary of the will. And that includes your executor and their spouse, because an executor of a will does have an entitlement to take compensation from the estate. And if you do have someone sign, let's say I have my spouse sign my will and I've also left everything to him, it can invalidate the gift to him. So definitely important to make sure that you're witnessing it properly. Then the big question is, how can someone actually create a will? So in Canada, there's about 4 different ways that you can do it. And I've ranked them from cheapest to, I should have switched lawyer and online platform, but they range from, free all the way up to hundreds, if not thousands of dollars. And they range from really simple to complex. So again, there's no wrong way to go, but I'll try to give you some of the objective pros and cons of each. The holograph will, I'll start there. That is a handwritten will. So it is the only type of will in Canada that does not require witnesses. The requirements to make a holograph or handwritten will are you take pen to a piece of paper or a napkin or whatever surface. And as long as you don't use any kind of mechanical process, it has to be 100% in your handwriting and you sign it. That is a valid will. So especially if you are quarantining or you have some sort of legal knowledge that would help you to know what to put in that, it might be a great option for you. There's a couple kind of notorious cases in Canada of holograph wills. The first is in Saskatchewan. There was a gentleman who, unfortunately, he's a farmer who was crushed by his tractor, and he took his pocket knife and he scratched his will into the side of the tractor, and that was held up as legally valid in court because it was his own handwriting. The second example is a gentleman in Ontario who, one of the questions was, can I write my will on a napkin? He literally wrote his will on a McDonald's napkin. I'm not sure what gave him the inspiration to write his will while he was eating his Big Mac, but he wrote it down and it was held up as valid in court. So the downsides to a holograph will are, often folks leave things out. So with a more comprehensive process, you might put in, just in case this person passes away, this person should receive my assets. In case my executor can't act in this role, I'm going to put in this backup. So it's not always the most comprehensive. And if you don't know anything about wills or what to put in there, you might find it actually more confusing than using a process that guides you through it. But again, totally valid, totally free. If you are in PEI, they're not valid there. And BC, they have some rules around using them for real property. They're not as common in BC. So just, make sure to do your research before you write a holograph will if you're in one of those provinces. The next level up from that is the DIY will kits that you might see on a government website or at a store like Staples. And so those are the physical, I call them Mad Libs for estate planning, where it's literally just fill in the blanks. They're usually affordable, 20, 30, 40 bucks, even free in some provinces. The government has kits that you can download that are free. The benefit is the cost and the ease of use of being able to fill it out at home. The downsides, again, are just it's not catered to your situation. So it's not always comprehensive. And a lot of people, unfortunately, when they use DIY will kits, they tend to mess up on the witnessing side of it. So they do have their beneficiaries sign. And I've heard from a lot of estate lawyers that these wills are often invalidated just because people aren't following the instructions correctly on the signing and witnessing side of it. So just be cognizant of that if you decide to go that route. The next level up from there would be a platform like Willful. We are not the only platform that exists. There's platforms like legalwills.ca as well. And really the benefits of a platform like ours are obviously, convenience, cost, accessibility. The downside is obviously we can't cater to really complex situations. We are like TurboTax, where we're designed to fit, simple situations. And so if you have complexity, then we can't help. And if you want legal advice, we're also not the right fit because we can't sit with you and give you direct legal advice. The good side about Willful is that we offer free updates in future. So you pay once and then you can make updates for free in the future. But again, if it's not the right fit for your situation, that's a moot point. And then the most expensive, but also the most comprehensive option is visiting a lawyer. So because of COVID, some lawyers are actually even offering services online. And a lawyer can, again, they can sit with you, they can offer you custom legal advice, they can write any sort of custom complexity into your will. But of course, there's a price tag that matches that. So, it's really a question of your budget, your situation, your preference, and you probably will, even if you start with a simpler situation, you may graduate over time to using a lawyer at some point in the future, just like I started with TurboTax and then I graduated to a lawyer a few years later, or an accountant, sorry. So what actually adds complexity? So there was a few situations in the questions that I received where I wanted to call out a few of them. So, one of them is separation. So if you're separated but not divorced, in the eyes of the law, you're still legally married. And in all provinces, family law dictates that spouses and dependents, whether that's dependent children or adults, who rely on you financially, have a right to a share of your estate. So if you're separated but not divorced, there's usually a separation agreement that addresses what happens in the event of one of your deaths prior to the divorce being finalized. And that typically you would want to have work in tandem with your will. And that's not something that we do on Willful. And I'll speak a bit about what happens when you pass away without a will, because I know that's probably a question on people's mind as well. I'm going to talk specifically, so Sandy, thank you for your question about your business. So I will speak briefly about this now, but I have a slide on it. So essentially with Willful, we have what's called a carry-on business clause. And that is a clause that allows your executor to step in and wrap up your business affairs as if they were standing in your shoes. So they can, sell a business, sell your shares, wrap things up, basically do anything that you would be able to do with the business. But we don't offer any sort of additional succession planning. So if you have custom wishes that you want written into the will, we can't cater to that. And we also don't handle dual wills, which I'll speak about later, but are essentially for tax purposes. You may also want to create multiple wills. So I had a few people in the questions who asked about assets in other countries or even assets in other provinces. I have a house in Ontario, I have a cottage in Quebec, I have a house in Alberta, I have a holiday home in Spain. I don't, I wish, but if that's the case, you don't have to create multiple wills. You can just create one will, and there may be tax implications in the other jurisdiction where you own property, but you can and may want to create multiple wills in each jurisdiction so that those assets are governed by the estate laws in that province or in that country. And in that case, you should have a clause in those wills. You typically have one that speaks to each other so that your family doesn't find one of them and have no idea that there's another will for that other jurisdiction. So that's not something that we handle. I also had a few questions about trusts, spousal trusts and complex family trusts. So the only type of trust that we create through our wills at Willful is a simple testamentary trust for minor children, which means that if you were to pass away and you had a child under the age of majority in your province, their inheritance would be held in trust and managed by your executor and estate trustee until they turn the age at which you specify in the will. But there are so many other types of trusts. There's life interest trusts, which say that someone can enjoy the use of an asset, like live in a home until they pass away, and then it goes to so-and-so. There are spousal trusts, which are really common with blended families to make sure that, your spouse can't cut your children out of the will when they pass away. So those would all be things that, that you would want to speak with a lawyer about. Conditional wishes. This is a fun one since I'm speaking to a university alumni audience. I had a woman call me once who said, can I stipulate that my son only receives his inheritance if he graduates university? And I said, well, that's called a conditional gift. You could do it. You just can't do it on Willful. So you can leave conditional wishes where either something has to happen for them to receive the gift, or when something happens, they stop receiving the gift. Like if they marry that person I don't like, they don't get any more. And you can write that in with a lawyer. One that I forgot here is also if you want to disinherit someone. So if you have a family member and you're sure that they're going to contest your will, or you want to cut them out, a lawyer can actually write in specifically why you're not doing something. So with Willful, you're saying, I want to do this. I want something to go there. A lawyer can say, I don't want cousin Joe to get anything because I haven't spoken to him since 1970, but I know he's going to come after my will. And a lawyer can also take notes about why you haven't included people and provide that to the court if they're ever called as a witness. So that's another good example. And then, maybe you just want legal advice, right? Maybe you're totally fine with the DIY approach. Obviously, we offer customer service, phone, email, live chat, etc. But we can't give you legal advice. We can only give you legal information. Totally valid reason to visit a lawyer. So I have some questions here, which are great. I'll get to a couple of them now, actually. So is a will created through Willful legally binding across all of Canada? So it's legally binding in the province in which you created it. So let's say you live in Ontario and you create it in Ontario, then our back end recognizes you're in Ontario, it updates the content of the will, and that would be true if you created it in any other province. If you moved, let's say, to Nova Scotia, most provinces in Canada recognize wills created in other provinces at the time that you pass away. But it's best practice to update your will when you move provinces. Another question on, do we need to account for shoppers' optimum points to Sephora Rewards? So I'll get to that for specific gifts. That's great. And the other ones I'm going to be answering. I'm also going to get to the updating wills and whether it replaces existing one. And JS, just to answer your question, is it better to do the basics using one of the non-lawyer methods and then take it to a lawyer? So the only challenge with that is that a lawyer is not going to take a willful will and build on it because they have liability for the wills that they create. So they're going to write it from scratch for you. So if you want to buy a will kit or use something like Willful to help guide you through the decisions, you can actually use Willful all the way through to the end without paying. So if you just want to use it to see what do I need to know, what are the answers, you can absolutely do that. But if you brought it to a lawyer, they're going to start from scratch with their own legal content because it's a liability issue for them. So I had a few questions prior to joining about what happens if you die without a will, what happens to your assets. So I'll go through that briefly, just in terms of what happens to your assets and dependents. So if you die without a will, you have passed away what's called intestate. And that's just a fancy word for died without a will. So what does that mean? Well, it means that there is a provincial formula that dictates how your assets will be distributed. If you literally Google intestacy rules X province, you'll see exactly on a government website how your assets will be distributed. And I often hear the government takes my stuff if I pass away without a will. That is only true in the rarest of cases. So I'll use Ontario as an example. If I have a spouse, the first $200,000 of my estate goes to them. If I have kids, it's split between my spouse and my kids. If I have neither, it moves down the line to my close relatives, parents, siblings, aunts, uncles, cousins. If there's no living heir that they can find, then the government would take your assets. So it's really only in that case. But the key to remember is that if you don't have a will and if you don't plan to get one, Google those intestacy rules to make sure that when you pass away, your wishes actually match up with the formula that would be distributed. A lot of people say, oh, it's okay, my spouse would just get everything. And that's not true if you have children. Part of your estate goes to your spouse and part of those assets would be tied up for your children. So, it's really important to understand if what you think is the default actually is, and having a will is a way to control where those assets go versus relying on the default. I had a question about common law spouses. If you are in a common law relationship and you pass away without a will, there is absolutely zero entitlement in that provincial formula for common law spouses. Now, that doesn't mean they won't get anything. they have the right, just like anybody, to apply for a share of the estate. And they may be able to prove, okay, we had been living together for this long, we were living like spouses, but it's up to the courts whether they actually give that person anything. So if you're in a common law relationship, it can be even more important to have a will that clearly lays out how you want that common law spouse to receive your things. And then when it comes to minor children, the court is actually going to appoint a guardian. So people always say, well, I can't create my will because my spouse and I can't decide on guardians for our children. And I always say, well, picture the person that you absolutely don't want to be the guardian, like your brother-in-law. If you pass away without a will, anybody can apply to the court to be the guardian. The court's going to make a decision based on evidence of what's best for the child, and it might be that person that you don't want. So same with your administrator of your estate. In a will, you can appoint an executor to do that. If you don't have a will, anyone can apply to be the administrator to wrap up your estate. And it just takes longer. So really, creating a will is not for you. It's like life insurance. It benefits the people you leave behind. It cuts down on time, burden. And again, here, if any of these things apply to you, it's definitely really important to consider. So what actually are the key elements of a will? Sorry, just keeping an eye on questions. Someone asked, who can you contact? I have contact info at the end, but I'll type in my info here. You can email me anytime. We also have live chat and customer service, but you can direct any more questions. And if I can't answer them, we can always reach out to our legal advisors, the estate lawyers that we work with in Ontario, to source an answer. One of those is in Guelph. I know it's not Hamilton, but happy to share his info if that would be helpful. And so I'll get into the key elements of a will. Now, Bev asks about whether it's best to have an individual will. This is a question I get all the time. Joint wills are very uncommon. A joint will is a legal document that binds the surviving spouse, and so they're unable to change the will. They're really only used in rare situations where, it's a blended family and they're much older, they don't think that they'll remarry. Typically what happens is when you create a will with your spouse, you can create what's called a mirrored will, which essentially just mirrors some choices. So you can say, I want to leave everything to you if I pass first. You leave everything to me. If we both pass at the same time, we leave everything to the kids. So your choices are mirrored, but the documents are separate. You each have individual wills, individual powers of attorney. And that's the most common way to make a will with a spouse. And your choices don't have to be mirrored. You each have your own individual estate with your own assets that flow through it. So you can make a will that doesn't look the same as your spouse. For example, if we don't have children, so if my spouse and I pass away at the same time, I want my assets to go to my sister and my mom, and he wants his to go to his brother and his dad. So our individual wills stipulate that. So hopefully that answers that question. The question here about fees with Willful, a will, $99, free updates, will and power of attorney, $149, free updates. So key elements of a will. The first thing that you're going to do is you're going to choose an executor. So as I mentioned, the executor is the person who executes the wishes outlined in your will and who wraps up your estate. They handle the estate administration process, which I'll speak about a bit later. They're going to do things like paying off debts and taxes, compiling a list of your assets, and selling assets if needed. They're going to distribute the gifts to your beneficiaries, and they're going to keep in contact with your beneficiaries during that time. So they're handling a ton of work. And I always say, people think choosing an executor is like choosing a bridesmaid for a wedding. You're choosing your favorite person, but really being an executor is not the most fun job. It's a lot of work. It's a lot of paperwork. And it can require being really meticulous and organized and a great communicator. So it's really important to think about who would be the best fit. I had a question about professional executors. So you're right, this doesn't have to be a family member. In many cases, people appoint their spouse or their siblings, parents appoint their adult children. It could be a friend that's really organized, but a lot of people don't want to put that burden on a family member. So they'll appoint a professional executor. And that can be a trust company, the trust division of a bank, a professional executor. There's a company called Estate Transition Planners in Waterloo that does this, or even a lawyer. The thing to note is on Willful, we don't accommodate professional executors at the moment, just because they have a special compensation clause that goes in the will, and it's different for every professional executor. So it's tough for us to accommodate. But if you don't want to put that burden on a family member, it can be a great option. And it's also important to note that your executor can hire professionals after the fact to help them with estate administration. So if I appoint my husband, Kevin, and I pass away, he can hire Debbie from estate transition planning to help him through that process, so he doesn't have to muddle through it on his own, and that becomes an expense of the estate, so he doesn't have to pay it out of pocket. And it's also important to appoint backups. If you appoint an executor in your will, they are not legally bound to accept that role. And if they decline it and you haven't assigned backups, it basically defaults to as if you passed away without a will, and the court then has to appoint someone to act in that role. It's also really important to inform your executors. You would not believe the number of times I hear, I appointed my brother Steve as executor, but I haven't told him yet. And I always say, this is a big job. No one wants to be surprised with it. Make sure that you run it by them, that they're okay with it, because the worst case is you appoint an executor in your will, they didn't know about it and they don't want to do it. And all of a sudden you find yourself defaulting to the courts having to appoint someone. And it's also important when you create a will to tell the executor where it is. Lost wills are a massive problem because people don't tell people, and they sit in, filing cabinets or at work or in safety deposit boxes. Actually, Aretha Franklin passed away without a will, and they found a handwritten will in the couch cushions a year after her death. So that was a crazy one, but definitely important to inform your executor. And you can also register the will on the Canada Will Registry, which allows your family to perform a search after you pass away. If you are an executor in a will and you're wondering what's involved with that, you can check out a Canadian tool called Executor Depot, or you can go to willful.co/learn, and we have a ton of resources there just on what that role means. Choosing beneficiaries. So the next thing you're going to do is you're going to say who gets your stuff. This is one of the key components of your will. After you've named your executor and your backups for that role, you're going to decide which individuals or organizations get all of your stuff. And that could be financially valuable, or it could just have sentimental value. So the first way that you can leave something in your will is as what's called a specific gift, or you might have heard it called a bequest. That is a specific identifiable thing that you're giving to a specific person. That could be a home or a rental property, jewelry, a recipe book, the contents of a bank account, an amount of money, anything you want. That again has monetary or sentimental value, and that's going to a specific person. Now, you can also leave a specific gift to a charity. So we're very passionate at Willful about influencing the amount of gifts to charity in wills. Only about 12% of Canadians plan to leave a legacy gift. And in my opinion, as someone who is not a millionaire, it is an absolutely amazing way that is zero cost to have a positive legacy. So you can leave a cash gift to a charity using the specific gifts, or you can leave a percentage of your residue, which I'm going to speak to in a moment. And you can actually, if you're so inclined, obviously completely up to you, but McMaster is one of our featured organizations in our drop-down charity list. And so we're excited to support them in helping anyone kind of leave a gift to McMaster when you pass away. So after you've put all of those specific things out, you can then choose how the residue is distributed. The residue is what's left after debts and taxes are paid, and all of those specific gifts are distributed. So after you pass away, your executor is going to pay the CRA, which I'll speak about in a moment. They're going to, pay off any debts, like if you had credit card debt. I'll also speak about debts in a moment. They're going to give out any of those specific gifts, like the $5,000 gift I left to my cousin. And then what's left, think of it like a pie chart. It's a group of assets, money, properties, investments, etc. And that is your residue. And you're going to divide that up by percentage. So you can divide it up 1% to 100 people or 100% to one person. And you're also looking to provide layers of backups here. It's very common for people to create their wills, leave them in a filing cabinet for 20 years, and by the time they pass away, their beneficiaries have passed away, and all of a sudden, you're defaulting to that provincial formula. So with Willful, we allow you to assign backups, so you can say if one person passes away, their share would be split amongst the others or go to their children. And we also have what's called a contingent beneficiary, which is essentially like a disaster clause. Many of our customers are, a nuclear family of, not all, of course, we have tons of different people using it, but especially when you, a spouse, and the kids, they say, well, what happens if all of us get in a plane crash? A plane crash is always the thing that people say, even though the chances of it, especially now, are so minuscule. What happens if we all pass away together? Think of a contingent beneficiary like your ultimate backup. Now, again, it's totally up to you if you use, put people or organizations. I've actually assigned charities as my contingent because I know that a charity will always be around. And so they can always receive that money and my estate won't default to the provincial rules. The next big component of a will is planning for minor children. So if you don't have minor children or dependents, then this isn't a big deal for you, but this tends to be the absolute biggest blocker for people doing their will, is assigning guardians for minor children. So really you're assigning someone to manage their finances, the finances for them, and also take care of them. Tends to be the same person is on Willful. And it can be, family member, close friend, someone who would want to look after your children and who has the capacity. Again, you want to talk to them. You want to appoint backups in case they're not able to do it because they are not legally bound to take on that role. And in your will, you're typically also stipulating at what age children will receive their inheritance. So again, if they're a minor, that money would be held in trust and managed by the trustee, who in Willful's wills is the executor, but if you visit a lawyer, you can appoint separate executor and a trustee to manage those funds. And you can say, you know what, I want them to get it when they're 25. I don't know about you, but I was not responsible enough at 18 to get a big inheritance and spend it responsibly. So a lot of people like to give it to their kids a little bit later on. And don't forget pets. I'm a big proponent of planning for pets in wills. Unfortunately, it's one of the top reasons that pets end up in shelters. So you can assign a pet guardian to take care of them. And you can also assign a specific gift, an amount of money for their care. My mom has 2 horses and they are not cheap. So always good to think about leaving money for their care. And I did want to get back to the question about business owners. So Sandy asked about, we're business owners, should the business form part of our will? So when you pass away, your will, your business assets would fall under your will, unless you had something structured with like a trust or a holding company where it wasn't actually a personal asset. So that's something where you may want to speak to, your corporate lawyer about that, or even speak to a financial advisor about the structure there. But assuming it was a personal business, like a sole proprietorship in your name, or you had shares in a business, it would flow through your estate. And again, Willful has a carry-on business clause that outlines what happens when, or allows your executor, to step in and take care of things, wrap up the business, etc. You can also work with a lawyer to build in a lot more succession planning info. A lot of times people will create what are called dual wills. A dual will is a secondary will just for your business assets that saves you from having probate fees on your business assets. It's solely a tax planning vehicle. So if you don't have a dual will and you pass away, you just have a regular will, it's not like your business assets won't be covered by that. It's more just that they will be subject to probate fees, which are about 1.5% in Ontario, and they differ by province. It's also just good to check your shareholders agreements, especially if you have a business that's a bit larger or you've invested in private businesses. And to document your wishes. I mean, this is outside the conversation about the will, but I'm very passionate about that. If you're the only person that knows passwords and how to access things, and nobody knows what you would actually want when you pass away or how they'd be able to carry on operations, it's important to document that stuff and to also talk to your executor about what you would really want to happen to your business when you pass away. So hopefully that helps, Sandy. I also did want to talk about will alternatives quickly. I mentioned this earlier, but people often say, what if I own a home jointly? What if I have a joint bank account with my spouse? What if I want to gift a house to, own it jointly with my adult child before I pass away? So there are what are called will alternatives, and all of these will alternatives do not flow through your estate. So again, if you think of your estate as this pie chart, these are things that kind of sit over here in a separate pie chart. So that includes, life insurance policies that have a beneficiary named directly on them. People often do that because they can pay out in a matter of weeks versus the 12 to 18 months for estate settlement. So that doesn't flow through your estate. Registered savings accounts like RRSPs or pensions that have a named beneficiary, those also go directly to those folks. And if you own your home jointly with rights of survivorship versus jointly with tenants in common, two separate types of joint ownership, joint with rights of survivorship means that when you pass away, the property just goes to the spouse because they're a joint owner. Same with any joint investments or bank accounts, just goes to the other person. Same with any debts that are jointly held. Debt just goes to the other person. And another way you can gift things and, without putting it in the will is what's called an inter vivos gift, which is a gift while you're still alive. And someone had a question about gifting to your adult children. Be very careful if you are gifting, if you are jointly on a property or bank account with an adult child. It's not enough to just add them to title. The courts want to see evidence that you intended them to receive the asset when you pass away. And often that includes a letter or something like that that shows the intention that you had for that to actually go to the adult child. That's not the case with spouses. They just assume, yes, I jointly own this with my spouse. So updating your will, we had a lot of questions about that. And I do want to be cognizant of time. I had a question from someone who asked about, doing a demo of the Willful platform or potentially answering more questions. So I will leave that to Anne-Marie and the team at McMaster, but I'm always happy to set up time to go through a demo. We're actually having the same lunch and learn tomorrow at noon. There's a public link on my Twitter. So I'll send that to Anne-Marie, and I'm doing a demo of Willful from 1 p.m. to 1:30 tomorrow. So if you do have the time and you want to see a platform demo and walkthrough, I'll make sure that Anne-Marie sends out those details, and I'm always happy to hop on and do this again, or just do a Q&A session and maybe even have a lawyer join me who can speak to the more complex stuff. So updating your will. When you may want to update your will. Few instances, you have a child you want to add in as a beneficiary, or you need to assign a guardian for them. You got married. In Ontario and many provinces, if you have a will and you get married, it is automatically invalidated by law. So that's a good one. If you get separated or divorced, fun fact, if you get divorced in Ontario and most provinces, your spouse is treated as, ex-spouse is treated as if they predeceased you, as if they passed away first. So they will not receive a gift in your will if you forget to update it, but still important to update it and remove them and add people that should be in there. Maybe you purchased a new asset that you want to leave as a specific gift. You don't need to update your will every time you buy an asset though, because unless you want to give it specifically to someone, it just falls into your residue. You don't need to worry about it. You move to a new province, you should update it. Change in roles, new executor, new guardian, etc., or the death of someone who's named in your will, because you'll want to remove them and add someone else. The ways you can update your will. So a few people asked, I have a will already. If I were to update it, either with Willful or otherwise, what happens to it? When you make a change to, when you make a new will, automatically by law in Canada, it revokes any previous will. We also have a specific revocation clause in our will that says, yes, I revoke any previous ones. So when you execute a new will, you sign, witness the whole shebang, that's your new legally valid will. You should destroy, or it's best practice to destroy any other version so your family doesn't find an out-of-date one. And then you just have a new one. So you don't have to update the old one. You can just create a net new one. If you do already have a will and you don't want to start from scratch, you can add what's called a codicil, which is basically an addendum. This is something that can be done by a lawyer. This is not something that we offer on Willful. And it's also legally allowed to make what are called handwritten alterations, which is you taking a pen to your will, whatever type of will it is. I would just caution that there are very specific laws around how you have to have alterations witnessed. So if you're making handwritten changes, just make sure that you look those up. And so with Willful, essentially, you can make updates for free at any time. And when you make an update, it's reflected in your documents and you just have to print and sign them again. So you do have to go through that process. At that time, then that will becomes the new one. You destroy the previous one. It's totally free. You just have to do the signing again. Someone did ask me about, can I store my will online? No, it's not legal anywhere in Canada to sign your will electronically or to store it online. You have to have an original copy. That is only the original signed paper copy of the will is valid. If you make photocopies and you give them to family and friends, great, but only the original copy is going to be the one that they're going to be able to action. And again, at the time the new will is signed, it automatically revokes the old one. So I wanted to finish off. I know we had a lot more questions, but I'll just talk about a few things that I think cover a bunch of the questions that came in. And the question about shoppers optimum points, you in many cases can leave those things as specific gifts, but some of them have terms and conditions. So it's always good to actually reach out to the program directly to see if you're able to gift it in your will, because they do have some terms and conditions for each of them. If you jointly own with your spouse, do you still need a will? If you pass away without a will, even if you own property jointly, the courts still have to appoint an administrator, still takes longer, still guesswork for your family. So my answer is you should have a will if you have a spouse, dependents, or any type of assets, because it's not just, not every single asset that you own is likely jointly owned. And even then they would still have to apply to be an administrator with the court. And within Willful, a great question about documenting other wishes. One of the things I won't have time to touch on today is all of the stuff that you can create and store with your will that's hugely valuable to your family and your executor. Those are things like a list of your assets, a contact sheet of your witnesses and your beneficiaries, your list of subscriptions that you have that need to be canceled, any other wishes that aren't legally binding, like funeral and burial wishes. All of those things are super helpful. Right now, we don't have a place to record those. We do ask you about funeral and burial wishes, and those are included in your will. But outside of that, you can just document that in Drive, Google Drive, or in a cloud program via email, or you can write it out on paper and store it with your will. And we are working on ways to store that information with us, whether or not you create your will with us. So I did want to touch on debts and taxes. We had a bunch of questions about that. So when you pass away, there are two main types of tax. There's your final income tax return, and then there's probate fees. So yes, the tax man still comes calling when you pass away. Your final income tax return will be filed by your executor. And if your estate is subject to probate, then your estate will also be subject to probate fees, which, as I mentioned, are equal to about 1.5% of your assets in Ontario. When do you have to go through probate? What is it? Probate is the process of formally accepting a will in the court system and formally approving your executor to act on your behalf. It's not always required, but it's typically required, especially if you own property or you have an estate that's a bit larger, so over 50 to 100K. It can also be required by financial institutions since it cuts down on their liability associated with estates. So it's not always a black and white. Sometimes it's a gray area, but it's usually assumed that your will need to go through probate. Your executor will be in charge of, again, paying any of those fees. They'll pay any of the estate fees, as well as all of the expenses, like hiring professionals to help you. And on the note of debts, so when you pass away, your executor is going to make a list of all of your assets and all of your debts, and they're going to pay off your debts out of that pie that's left of your assets, and the remainder is going to go to your beneficiaries. If your debts are larger than your assets, so let's say my residual estate is $400,000 and my debt is $1 million, then your estate becomes what's called insolvent. It's essentially like being bankrupt. And, the debtors there's an order in which they receive assets, mortgages are typically, and secured loans are typically first, and then the rest. And so, it's not that debt passes on to your beneficiaries. There is no inheritance tax in Canada. So by the time that comes to your beneficiaries, they don't have to pay taxes on it. The exception is a mortgage. A mortgage typically stays with the house. So let's say, for example, I gift my sister a house and there's a $200,000 mortgage on it and the house is worth $500,000. then she could either assume that mortgage or she could sell the property and net the $300,000, assuming it's my primary residence, not a rental property, in which case she'd also have to pay capital gains. So on that note, minimizing taxes. So you can, I'm not an expert on this. My suggestion is always talk to a financial advisor if you're thinking about minimizing taxes. But here are a couple of the things that you can think about. Joint ownership reduces the amount of capital gains that are triggered when you pass away through things like investments that transfer to someone else, spousal rollovers, for example, of RSPs. Charitable gifts actually minimize taxes because you get a charitable receipt just like you do while you're alive. Dual wills, which separate business assets or other assets and save them from going through probate. And then there are also some complex things like estate freezes and family trusts. And those are absolutely things that you need to visit a lawyer for. So I'm going to end there. To me, the takeaway is a will is just the tip of the iceberg. And so compiling all that other information outside the will can really help, but don't get overwhelmed. Start with the will, which is, again, just a few key choices: executor, guardian, beneficiaries. That's pretty much it. It's a pretty simple document. Again, you can save on your plan with Willful. The team's going to email you around a link as well as more resources. And they're also going to send you a checklist that can help to prepare your will, regardless of where you do that, as well as a link to our Learn Center, which has a ton of just informational content about wills in general. And yes, I would love for you to share the poll results, my friends at McMaster, because, oh, here we go. So 67% of folks don't have a will, 23% need to update it. So it sounds like there is definitely some folks who either need to look into Willful or something similar. And I just want to thank McMaster for partnering with us. It means a lot. We're a Canadian small business. And we're really, really happy to have been here tonight and shared details with you. I hope it's been valuable. 55% of you said that you don't know where to start with your will. So if I can say anything, it's, again, even if you just want to start the Willful process, we don't ask you to pay till the end, and you can delete your account at any time. It'll just guide you through some of the questions and give you some of the tips that at least help you to record those things. And then you can take them to a lawyer or write your own will, but it can at least help with that. And I know a lot of you had questions either beforehand or now that I didn't have a chance to get to. Please email me at erin@willful.co if you have those questions, if you want me to source those, if I can't answer them. And I'm also happy to send them to the McMaster team to share around as well.